7.2c, Constitutional Convention. The words and actions of the USHx convinced many political leaders that only a much stronger federal government could solve the nation's problems. After most of the states had already appointed delegates, the Confederation Congress belatedly endorsed the proposed Philadelphia Convention for, quote, the sole and express purpose of revising the Articles of Confederation. In mid-May 1787, 45 men representing all the states except Rhode Island began to assemble in the Pennsylvania State House. The vast majority of delegates to the Constitutional Convention were men of substantial property. Their ranks included merchants, planters, physicians, generals, governors, and especially lawyers. 23 had studied law. In an era when only a tiny handful of men had advanced education, more than half of them had attended college. The younger delegate was 26. The oldest, Benjamin Franklin, was 81. Like George Washington, whom they elected their presiding officer, most were in their vigorous middle years. All favored reform. Most wanted to give the national government new authority over taxation and foreign commerce. Yet they also sought to advance their state's divergent interests. A dozen men did the bulk of the convention's work. Of those, James Madison of Virginia most fully deserves the title Father of our Constitution. A Princeton graduate A Princeton graduate from Western Virginia, he had served on the local committee of safety and was elected successfully to the provincial convention, the state's lower and upper houses, and the Continental Congress in 1780 to 1783. A promoter of the Annapolis Convention, he strongly supported further reform. Madison carefully prepared for the Philadelphia meeting. Through his close friend Thomas Jefferson, he ordered more than 200 books on history and government from Paris, analyzing their accounts of past republics. A month before the convention began, Madison summed up his research in a paper entitled Vices of the Political System of the United States. What the government most needed, he argued, was, quote, such a modification of the sovereignty as will render it sufficiently neutral between the different interests and factions. Rejecting the common assertion that republics had to be small to survive, Madison asserted that a large, diverse republic was less likely to succumb to the influence of a particular faction. No one set of interests would be able to control it, and political stability would result from compromises among contending parties. 7.2d, Virginia and New Jersey plans. The so-called Virginia Plan, introduced on May 29th by that state's governors, Edmund Randolph, embodied Madison's conception of national government. The plan provided for a two-house legislature with the lower house elected directly by the people and the upper house selected by the lower. Representation in both houses proportional to property or population, an executive elected by Congress, a national judiciary, and congressional veto over state laws. The Virginia Plan gave Congress broad power to legislate, quote, in all cases to which the separate states are incompetent. Many delegates believed the Virginia Plan went too far in the direction of national consolidation. After 2 weeks of debate on Randolph's proposal, disaffected delegates, particularly those from small states, united under the leadership of William Paterson of New Jersey. On June 15th, Paterson presented an alternative scheme, the New Jersey Plan. He proposed retaining a unicameral Congress in which each state had an equal vote, while giving Congress new powers of taxation and regulation. Although the convention initially rejected Paterson's position, he and his allies won a number of victories in the months that followed. The delegates began their work by discussing the structure and functions of Congress. They readily agreed that the new government should have a two-house or bicameral legislature. Further, in accordance with America's long-standing opposition to virtual representation, they concurred that the people, however defined, should directly choose the members of at least one house. But they differed widely in their answers to three key questions. Should representation in both houses of Congress be proportional to population? How was representation in either house to be apportioned among the states? And finally, how would the members of the two houses be elected? The last issue proved the easiest to resolve. To quote Pennsylvania's John Dickinson, the delegates deemed it essential that members of the lower branch of Congress be elected directly by the people, and expedient that members of the upper house be chosen by state legislatures. This strategy had the virtue of placing the election of one house of Congress a step removed from the lesser sort, whose judgment the wealthy convention delegates did not wholly trust. The possibility of proportional representation in the Senate caused greater disagreement. Small states, through their spokesman Luther Martin of Maryland, argued for equal representation in the Senate. Such a scheme, they roughly supported, would give them relatively more power at the national level. Large states, on the other hand, supported a proportional plan, which would allot them more votes in the upper house. For weeks, the convention deadlocked. A committee appointed to work out a compromise recommended equal representation in the Senate, coupled with a proviso that all appropriation bills originate in the lower house. Only the absence of several opponents of the compromise at the time of the vote averted a breakdown. 7.2e, Slavery and the Constitution. The remaining critical question divided the nation among sectional lines rather than by size of state. How was representation in the lower house to be apportioned? Delegates concurred that a census should be conducted every 10 years to determine the nation's population, and they agreed that native peoples, who paid no tax, should be excluded for purposes of representation. Delegates from states like Virginia and South Carolina with large numbers of slaves wanted to count inhabitants of African descent and those of European descent equally for the purpose of representation, though not for taxation and certainly not for the rights of citizenship. Delegates from states with few slaves wanted to count only free people. Slavery thus became inextricably linked to the foundation of the new government. The convention resolved the dispute by using a formula developed by the Confederation Congress in 1783 to allocate financial assessments among states. 3/5 of slaves would be included in total populations. The formula rejected delegates' judgment that slaves were less efficient producers of wealth than free people, not that they were 3/5 human and 2/5 property. What came to be known as the 3/5 Compromise on representation won unanimous approval. Only two delegates, Governor Morris of New York and George Mason of Virginia, later spoke out against the institution of slavery. The 3/5 clause not only assured Southern voters congressional representation out of proportion to the free populations of their states, but also granted them disproportionate influence on the selection of the president. In return for Southerners' agreement that Congress could pass commercial regulation by a simple majority vote, New Englanders agreed that Congress could not end the importation of slaves for at least 20 years. Further, the Fugitive Slave Clause, or Article 4, Section 2 of the Constitution, required all states to return runaways to their masters. By guaranteeing that the national government would aid any states threatened with domestic violence, the Constitution promised aid in putting down future slave revolts, as well as incidents like Shays' Rebellion. Although the words slave and slavery never appear in the Constitution, the framers used such euphemisms as other persons. 11 of its 84 clauses concerned slavery in some fashion. All but one of those 11 protected slaveholders and the institution on which their wealth and power rested. Sorry, I don't think I read that right. All but one of these 11 protected slaveholders and the institution on which their wealth and power rested. 7.2c-f, Congressional and Presidential Powers. Having compromised on the knotty, conjoined problems of slavery and representation, the delegates readily achieved consensus on other issues. All concurred that the national government needed the authority to tax and regulate foreign and interstate commerce, but the delegates stopped short of giving Congress the nearly unlimited scope Randolph had proposed. Sorry, that didn't come out right. Let me start over. Having compromised on the knotty conjoined problems of slavery and representation, the delegates readily achieved consensus on other issues. All concurred that the national government needed the authority to tax and to regulate foreign and interstate commerce, but the delegates stopped short of giving Congress the nearly unlimited scope Randolph had proposed. Discarding the congressional veto contained in the Virginia Plan, the convention implied, but did not explicitly authorize, a national judicial veto of state laws. Delegates also drafted a long list of actions forbidden to states, including impairing contractual obligations. In other words, preventing the relief of debtors. Contrary to many state constitutions, they stipulated that religious tests could never be required of U.S. office holders. The convention placed primary responsibility for the conduct of foreign affairs in the hands of a new official, the president, who was also designated commander-in-chief of the armed forces. With the Senate's consent, the president could appoint judges and other federal officers. To select the president, delegates established the Electoral College, whose members would be chosen in each state by legislatures or qualified voters. If a majority of electors failed to unite behind one candidate, the House of Representatives would choose the president, who was to serve for 4 years and be eligible for re-election. The Constitution created a national government less powerful than Madison and Randolph's Virginia Plan had envisioned. It distributed political authority among executive, legislative, and judicial branches of the national government, and divided power between states and nation, a system known as federalism. The president could veto congressional legislation, but that veto could be overridden by 2/3 majority in both houses. Treaties and major appointments required the Senate's consent. Congress could impeach the president and federal judges, but courts appeared to have the final say on interpreting the Constitution. 2/3 of Congress and 3/4 of the states had to concur on amendments. These checks and balances would prevent the government from becoming tyrannical. Yet the elaborate system would sometimes prevent the government from acting decisively. And the line between state and national powers remained so blurred that the United States fought a civil war in the next century over that very issue. The convention held its last session on September 17, 1787. Benjamin Franklin had written a speech calling for unity. Because his voice had grown weak, another delegate read it for him. Quote, "I confess that there are several parts of this Constitution which I do not at present approve," Franklin admitted. Yet he urged its acceptance, quote, "because I expect no better and because I am not sure that it is not the best." All but 3 of the 42 delegates still present then signed the Constitution. Only then was the document made public. The convention's proceedings had been entirely secret, and remained so until the delegates' private notes were published in the 19th century. Congress submitted the Constitution to the states in late September. The ratification clause provided for the new system to take effect once it was approved by special conventions in at least 9 states, with delegates elected by qualified voters. Thus, the national Constitution, unlike the Articles of Confederation, would rest directly on popular authority. The end.